And that it's a kick-out that we not do YouTube. I know that when we were doing the pandemic, we would ask that for kick-out hearings, they not be on YouTube just because of the sensitive nature.
Okay, I will ask, or we can ask.
Judge
We
Manger.
are here for an emergency hearing and counsel, you may proceed on the motion or on the application.
Wait, we need to, I need to do the interpreter channel, but they've changed everything and I don't see where it's. I'm not seeing it on our, they've changed the format of. I don't see where it shows the interpreter channel.
I do not see it either. Ms. Alfonso, do you want to call her and do it that way?
Yeah, I can do that if that works. Yes.
Oh, here's
Señora,
I did find the interpretation. I find it now.
Okay, ya, parece que.
All right, Ms. Riley, you may proceed
Señora
on the
Riley puede
application.
proceder en la solicitud.
And Your Honor, given the sensitive nature of our request, I would ask if the court would be okay with the YouTube channel being turned off for this proceeding.
Se apague el canal de YouTube en estas diligencias.
No,
creo que eso cumple con las normas de las audiencias públicas, así que voy a denegar esa petición de que se transmita esto por YouTube.
But you may proceed.
Pero puede proceder.
Okay. Hillary Riley, Assistant County Attorney, appearing for the state of Texas, and at this time, we are requesting a temporary ex parte protective order, which also contains a kick-out provision.
Yes, and I have had an opportunity to review the affidavit and the application, and I think the allegations are troubling enough to warrant granting the application, given the recent violence and the nature of that violence.
De la violencia.
I don't think I have any questions for you,
creo
Ms.
que
Riley,
tengo
or
ninguna
for, I
pregunta
don't,
para
I don't
usted,
know
señora
if there was
Riley, o
anything
para
new
ella.
that your
No
client
sé si hay
wanted
algo
the
nuevo que
court
su
to be aware
clienta
of.
quiera que yo
Let me
sepa,
know on that.
pero hágame saber si es el caso.
And certainly can ask Ms. Ramirez, but
Sí,
my
desde luego,
indication from my paralegal
puedo
this morning
preguntarle a la señora
is
Ramírez,
that
pero
there
lo que yo
has
sé
been
por
no
mi paralegal es que
recent
no
contact
ha
since we
habido ningún
originally
contacto
filed the
reciente desde que
application on
hicimos la
Monday.
solicitud el
And
lunes.
we do have an exception. They do work at the
Tenemos una
same
excepción,
place, so there is an exception for
trabajan en
them
el
to
mismo
be at the
lugar,
same
así es una excepción,
location, but then
de que estén
have
en el
a
mismo
certain
lugar,
distance, and
pero
that
tiene que
the
mantener
respondent
cierta
not communicate
distancia
with Ms.
y que el
Ramirez at
demandado
any
no se
time. But she did indicate to my paralegal this morning when we were notifying her at the 11 a.m. setting that she has not had any issues with him, and I believe that he has not even been at work over the last few days.
Ha estado en el trabajo los últimos 2 días.
And is he still in the residence
¿Y
at this
todavía
point
está en la
in time?
residencia en este momento?
No, Your Honor, after the
No, señoría,
incident on
después del
December
incidente
11th, he
el
did
11 de
leave the
diciembre, él se
home,
fue de la casa
and so she has
y ella
not had any
no ha
interaction
tenido
from
ninguna
him other than maybe some
interacción,
phone calls,
contacto con él,
but
tal
he
vez
did
una
leave the
llamada de
home.
teléfono, pero él se fue de la casa.
And we know from
Y
experience
sabemos
that
por
on occasion,
experiencia de
after
que a
entry of
veces,
these orders,
después de que se emiten estas órdenes,
it may have the
podría,
opposite of the
tendría
intended
el
effect
efecto
as far as
opuesto de lo que se quiere
violence.
hacer.
And counsel, will you
Y
let me know
abogada,
whether
usted me
you
haría saber
and
si
Ms.
usted y
Ramirez
la señora
have
Ramírez
discussed
han hablado
safety planning as far as that
sobre
goes?
Your Honor, she has been in contact with not
estado
only
en
counselors, but again, my
contacto
paralegal and another attorney with
con
our
la paralegal
office,
y
and
también
we
con otro
discussed
abogado
those
de
matters.
nuestra
But
oficina y
certainly,
hemos
if the
hablado
court is
con ella de
okay
esto,
and would
pero
allow us to
si
go into a
el
breakout
tribunal
room after
está
the
de acuerdo y
official
nos
hearing
permite ir a
has
una
ended,
sala
then I can go
de
over
espera
any other
después,
safety concerns she may
entonces
have
yo
and just
podré
reiterate the safety
revisar,
planning that
hablar
she's
con ella sobre
received.
cualquier otra preocupación que tenga
Fair
sobre
enough.
su
That sounds
seguridad.
good. Okay.
¿Suena bien?
Let me ask.
Déjeme que le
We
pregunte.
lost
Uy,
Ms. Ramirez,
Oh.
it looks like.
yeah.
Ms. Amposto, was she having issues with? Oh, there she is. Ms. Ramirez, are you still with us?
Señora Ramírez, ¿nos escucha?
Sí, se había desconectado, pero ya conectó de nuevo.
Okay. Sorry. Yes, she can hear us. For some reason, she lost the connection, but she's back.
Okay. And Ms. Anfaso, let me just ask, Ms. Ramirez, do you have any
Señora Ramírez,
questions of the
¿usted
court?
tiene alguna pregunta para mí? ¿Me quiere hacer alguna pregunta?
Yo quería decir que hace
I
un
wanted to
momento
say that a
él se
moment
contactó
ago
conmigo.
he contacted me.
Me solicitó
Was there
que
He
anything?
asked,
quería ver a los niños.
he said that he wanted to see the children.
And Your Honor, we have listed the children as protected people just to try to make sure that they are not
Señoría,
used
hemos
as pawns
incluido
in
a los
manipulation.
niños en
And
la
so we
orden de
would ask that
protección
the
como
court
partes
include
protegidas,
them,
así que
and I can
quisiéramos
certainly
que
go over that
el
with Ms.
tribunal los incluya
Ramirez
y podemos
between now
revisar
and
eso con la
Mauricia's
señora
setting on
Ramírez
January 2nd,
entre
how she can
ahora
handle that.
y en la audiencia del 2 de
Okay.
enero.
Ms. Ramirez, you understand that the court is
Señora Ramírez,
being
¿entiende usted
asked
que
to
este
enter
lo
a
que se le pide a
protective
este
order
tribunal es
against
que se emita una orden de
that would protect not
protección
only
que la
you, but
proteja
the
no solamente a
children
usted, sino
as
también a
well?
los niños? ¿Entiende eso? ¿Entiende eso?
Sí,
Yes.
Okay. And you are asking that the
Y
court go ahead
usted
and
quiere
issue
pedir
that
que
protective order.
esta orden emita esa orden de protección. ¿Es así?
sí.
Yes.
Okay. All right. Based
Bien,
on
entonces basado
the
en
affidavit and
la
the
declaración
application,
jurada
the court will grant the protective order.
y la
And Ms.
solicitud,
Riley, I
el
think the
tribunal va a
form is
conceder
in
la
good
orden de
order, so I don't think we
protección
need any
y
changes.
Riley, creo que la
I'm going to
forma
have Ms.
está
Seeger
bien,
set
creo que
up
no
that
tenemos que hacer
breakout
ningún
room.
cambio.
If
Le voy a
you
pedir a la señora
would
Seeger
like
que ahora
to
haga una otra
speak
sala
with
de
Ms.
reunión
Ramirez
virtual
now,
para
I'm
que
not
usted pueda
sure.
hablar con la señora
Might need
Ramírez
to invite
ahora.
her and the
No sé.
interpreter, everyone into that breakout room, and you're welcome
Espero
to
que también
use it
puedan ir todas a
until
esa sala de reunión virtual
conclude and then exit without coming back to
y
the
que luego se puedan
virtual
salir
courtroom.
cuando terminen
Okay,
de
thank you,
hablar
Your Honor.
sin necesidad de
All right.
regresar a esta
Thank
sala.
you. Best for the new year, everyone.
Muchas
Take
gracias.
care
Le
of
deseo lo
yourself.
mejor para el año
Good
nuevo y
afternoon. Welcome
cuídense.
to the 200th District Court. We're here for an emergency hearing in FM24. Ms. Lucas, I've read the application and your recitation of what happened. Let me just ask you a few questions. Is the respondent still in the residence?
He went to a hotel last night, and I'm not sure where he went or when he's going to be back.
Okay. And is he aware you're filing this application?
I don't think so. I don't know.
Okay. Have you spoken to anyone about getting a safety plan in place?
I have. I've spoken with victim services. I was kind of ready for something to happen. I just didn't know it would happen so soon. So it kind of caught me off guard. There was an incident back in May, and I had a protective order against him. I did let him back because he told me that he would get counseling and get help, and he never really did. And so it's just been getting worse.
Okay.
And I knew it was getting worse, so I was kind of making an exit plan. But then things escalated again. So yeah.
Okay. And you're currently expecting.
I am, yeah.
Okay. And he's aware of that. Okay.
Yeah.
And even though that's the situation, the violence and threats happened not just yesterday, but also on Christmas Eve.
Christmas Eve. No, it was just yesterday.
Okay, yesterday. Okay.
Yeah. And,
Okay. All right. Let me.
And don't get me wrong, I don't want him to go to jail. I don't want him to. I don't know what's going to come of this, but I want him to get help. I want him to be healthy, to be, a good father to my daughter. And he's not in a healthy place.
Okay. Well, this is a protective order, so this only will bar him from being the residence and being around you and the child.
Okay.
I noticed you wanted to keep information confidential. But you didn't provide an alternative person to give to receive notice and documents filed with the court. So I can only give you confidentiality if you're giving me the name and address of someone who can be contacted on your behalf.
Oh,
But since he knows where you live, I'm not sure that confidentiality, unless you're
think I
planning
just-
on moving, it's not going to be much.
right. And I think I just filled it out to my best of ability. I don't know if I understood what that has.
Okay. Well, it is late on Friday afternoon.
Yeah.
I am going to go ahead and grant the application,
Okay.
but it takes some time to get an order put together. I understand you don't have one. We will put
Okay.
one. We're putting one together,
Okay.
but then it has to be filed at the clerk's office, and then you
Yeah.
have to have him served.
Yeah.
So I just want to make sure it's not an automatic thing. It may
Yeah.
take a little bit of time.
Yeah, of course. Okay. I figured.
Also, you'll need to call the court administrator's office right away and get a hearing date.
Okay.
Yes, court administration, and they
It's-
can give you a hearing date, but this order is only good for 20 days.
Okay.
So you'll need to
And
set a
so-
hearing within that 20 days, and you'll need to let me know, email me or call, I guess, email me the
So is the
date.
hearing to get him excluded from the lease from the house? Or like he's going to have a protective order. He'll be able to get whatever stuff he needs with an officer present. And then and then after 20 days or the hearing, is that going to be if he's still on the lease or how does that
So
work?
the protective order is good for 20 days. It only
Okay.
excludes him from the residence and from being around you for 20 days.
Okay.
The
Okay.
second hearing determines what happens going
Okay.
forward after that.
Because my landlord might just be amenable to getting him off the lease after the 20 days or whatever, or by February 1st. So I can talk to her also.
Okay, well, that is something hopefully you'll be able to resolve one way or the other.
Okay.
But we will get the order signed and sent to the clerk. But
Okay.
they've got to accept the filing, and then you have to have him served with the order.
Okay.
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 So, be safe and take care of yourself.
Okay. Okay.
Sorry to meet you under these circumstances.
Okay. If I find out what hotel he's staying at or whatever, do I email somebody or we'll talk about that in the hearing or because I know he has to be served. And I don't know where he's staying right now at the moment.
Okay, well, he needs to be served with a copy of the order.
Yeah.
So if you don't know where he is,
Yeah.
law enforcement, you can try to have law enforcement serve him. They have ways of tracking people down.
Okay. Thank you so much.
All right, Ms. Seeger, anything else we didn't cover?
I was just gonna give you that, the clerk's office, the court administrator closes in 15 minutes, so I need to have the hearing date for the order, so their phone number is 512.
Okay, hold on, let me, I
can email it to you.
Can you? Yeah, that would be great. Thank you.
Okay.
Do you need me to call them right now?
Yes.
Yeah.
Okay. Okay.
I can't sign the order unless that hearing date is in the order.
Is that okay? Got it. Okay.
Yeah, it should be for basically around 20 days from now.
Okay. All right.
Could be sooner, but it can't be after.
Okay.
And if you need to, you can apply for one extension.
Okay.
But better to go ahead and get it taken care of.
Okay.
All right.
Thank you.
Thank you. Have a
Thank
good
you so
weekend,
much.
25.
Bye.
I'm going to start by calling the docket. When I call your case, let me know you're here. Let me know the total amount of time you need for the hearing and whether you need a record or not.
Yes, this is AJ Wilson Salazar with JT Wentworth Originations. We have an annuity transfer approved up today. We need about 10 minutes.
And who else is here on that?
Miss Patton Shuley is here. On
Right
that one.
here. That would be me.
Okay. And are you the annuitant?
Yes, ma'am.
Okay. Thank you. And no record, you said?
No, we don't need a record, Your Honor.
Okay, great.
I'm also
Next
here on
up.
that one, Your Honor. Hans Tweeten is here as the annuitant.
Oh, ma'am.
Okay. And no record on that one as well.
That is correct, Your Honor. We need about 10 minutes.
Dash 004265 Maddox versus BCC.
Judge Chelsea Akins for the defendant, third-party plaintiff
It's a motion for a partial default against the third-party defendant. I just need a few minutes, no record.
Anybody else here on that? Okay, thank you. Then next we have GN Jackson versus Uber et al.
Good morning, Your Honor. Brett Hargis here on behalf of the plaintiff. It's defendant's motion, but I think we're in agreement for the most part, so I don't anticipate we'll need more than a few minutes, and I don't need a record.
Good morning, Your Honor. Dave Larson here for the Uber, the Uber defendants. I would say it depends on where the hearing goes, Your Honor. I would say we need an hour set aside. It could go a lot quicker than that. We do need a record.
We don't typically give records on summary judgment hearings. Is there a reason for that request?
Your Honor, I can tell you it's a possible appeal issue later down the road. So we would need a record.
Well, summary judgment records are determined by what's in the file, not argument of counsel. That's why we don't typically give records. So I'm not sure I follow.
Yeah, Your Honor, it's simply making it part of the record. But if Your Honor is unwilling or it's really just a court procedure issue, then that is what it is.
Okay, well, we can talk about it a little bit later. But are there, for instance, are there objections to summary judgment evidence that we could give a record on? But argument by counsel is not typically recorded.
Yeah, understood, Your Honor. No, I don't think that there's any objections to the evidence.
Okay. All right. Next up, we have.
In Your Honor, sorry to jump in, Your Honor. I'm just co-counsel with plaintiff, but Attorney Brett Hargis will be presenting.
All right. Thank you. Riley versus Cornerstone.
Pete Rudder on behalf of plaintiff, Jody Riley King.
Your Honor, Tommy Gillespie on behalf of defendant Cornerstone. I would think 15 minutes at the tops and no record.
And Your Honor, I'm Mitch Ginsburg and I represent Dentex in this litigation. I agree, about 10, 15 minutes tops.
That's agreeable.
All right. Have you conferred about these issues?
We have, Judge. I think we've got an agreement on most everything except for one issue. So it may take less than 15 minutes.
All right. Fair enough. Thank you. And last but not least, GN3 Aguilar and Romero versus DoorDash.
Pete Rudder on behalf of plaintiff, and I think we do have an agreement on that one, Judge. If we can confer, I think we could shorten it up completely.
Your Honor, Scott Marcinkus on behalf of the movement. I'm happy to confer with plaintiff's counsel.
And Chad Robbins here on behalf of defendant Hall, just here to observe, Your Honor.
Right, counsel, do y'all want a breakout room to see if we can confirm your agreement before I call you back?
That'd be perfect, Judge.
Thank you, Your Honor.
Okay, and do we want Mr. Robbins too?
Yeah, that's fine.
He can join, yes.
Okay. Ms. Seeger, if you will send a breakout room to counsel on the last case. Y'all can just return to the virtual courtroom when you finish conferring. Mr. Woodby is going to send you that invite. Okay, I think.
Yeah.
Thank you.
Thank you, Your Honor.
Thank you.
All right. And I'm going to circle back around to, let's see. Let me start actually with the motion for default. And was that Ms. Aiken here on that one?
Yes, Judge.
Okay, hang on a minute. We got somebody else trying to join us. Let me find out who this is.
Judge, it may be the attorney for the plaintiff on this. He just emailed me for the link, so I sent it to him.
All right. Mr. Wagner, are you here on the default?
Yes, Your Honor.
Okay, and who do you represent?
We represent the plaintiff.
Okay. And Ms. Akins, you represent a third-party plaintiff seeking to default a third-party defendant.
Correct, Judge. This case involves the plaintiff falling off a ladder while doing some electrical work at a restaurant. My client, the defendant, third-party plaintiff, was the general contractor for the job. We third-partied in the plaintiff's employer, and they have not filed an answer. The case was filed by plaintiff July 11th, 24. We filed an answer September 6th of 24. We third-partied in the third-party plaintiff within 30 days. That was on September 20th of 24. They were served through their registered agent on file with the Secretary of State on October 7th of 24. Their answer was due October 28th of 24, and they have not filed an answer to date. The citation and the proof of service were filed with the court on October 28th of 24. So we're just requesting a partial default on liability based on there was a contract between my client, the general contractor, and the employer of indemnification and contribution.
Okay, a couple of things, Ms. Akins. I do not see that the motion for default was actually served on the defaulting party. Same issue with the notice of hearing.
Okay, I guess I could recheck the rule. I guess my knowledge was that notice wasn't required.
Okay, well, in Travis County, we have a local rule that requires hearing.
The notice to the defaulting party? Okay.
Well, when we have a hearing, we require notice. And
Okay.
so I don't grant any defaults unless the hearing has been noticed. And I think even when a party is in default, the rules of civil procedure still require all pleadings to be served on all parties.
Okay, Judge, we could certainly do that. We could reset and we'll make sure they get notice.
Okay. One other thing, just while you're here, you sued Mr. Hoskins individually and DBA SML Electric. Your motion says, well, we don't need a soldier's affidavit because it's an entity. I'm not sure that's right because you're suing a sole proprietor. I think I would be looking for that affidavit.
For that affidavit, okay. Yeah, that's the name of that they contracted under, was that name. I did pull the Secretary of State yesterday and I can't find an assumed name certificate, so I don't know where that came from. It may be, that it's not an assumed name, it's not a DBA, that it just is the entity. So I can certainly clean that up as well.
Yeah, I would, if it comes back to me, I would be asking questions, and I'm sure some of my colleagues would want to know that.
Sure.
Okay.
We will do that. Thank you, Judge.
I'll excuse y'all from the hearing. Thanks for your time.
Thank you.
Pardon me, Your Honor. Scott Marcinkus, you had put Attorney Rudder and Chad Robbins in a breakout room, but I wasn't provided the invite yet.
Oh, Mr. Woodby, can you resend that? Okay, you should see it pop up here in a second.
Thank you, Your Honor.
All right, sorry about that. I'm sure they're waiting on you. Okay, we are going to go back to the top of the docket. I'm going to ask folks here on the structure of settlement with Ms. Patton-Schul to be present. If you're here on something else, feel free to turn your video off until I call you back. Okay. Just trying to minimize the number of screens I'm scrolling through. Thank you. And all right, Ms. Wilson Salazar.
Yes, Your Honor.
You may proceed.
Thank you. Could you please swear in Ms. Patton-Schul? I'll be taking testimony.
Okay, I'll do that. But we didn't get any of the materials that are required to be sent to the court on these structures. Do you know what happened with those?
I'm so sorry. You should have received in an email the unredacted version. Did you not receive that?
I don't have anything on either case.
Oh, that's interesting.
Yes, and obviously our local, requirements are that those be submitted in advance. So
yes, that's very strange. I'll have to reach out to the law office and find out what's going on with that. I do know that we did not receive an order. I did get an email this morning saying that we're relying on the annuity company that is holding the money for disbursement to the annuitant. They help prepare to assure that it is in the correct format. And so they send that to the law office for us to be able to present to the court and fill in so we know we have the correct format for their business structure. We have not received that yet from the annuity company. So that might explain why you don't have an order, but it does not explain why you haven't received an unredacted version of the annuity documents. Would you like for me to reach out and have them send that to you and then let you know when I've received information that they have emailed it, or let me know what you would like me to do in order for us to proceed today?
Well, ideally, this would have been taken care of before the hearing.
Yes.
That's why we require it. It's so I'm going to be, if we proceed with the hearing, I'm absolutely blind to all of the documents on the case. So I'm not super likely to, grant the relief that you're seeking.
Let me double check and make sure that something may have not gotten, sent to the wrong email address. Let me see. Either way, you haven't seen it. I understand that, but I just need to see what may have happened on their end.
Do you want me to call both of these cases back again at the end of the docket and give you time to?
That would be great. We could do that if you could, Your Honor. I would appreciate it.
Ms. Patton-Schul, did you understand what's going on? There's paperwork that should
Yes, ma'am. I completely understand. It should have been sent to you ahead of time and it was not.
That's right. And Mr. Tweeten, that goes for your structure as well?
Yes, ma'am.
the court is supposed to receive and be able to review these documents before the hearing. I have unfortunately nothing. So we're going to let Ms. Wilson Salazar track that down. We're going to ask that everybody stay here in the virtual courtroom, but we're going to call you back at the end of the other hearings. Okay.
Yes,
so
ma'am.
Y'all are free to turn your video off and just wait here until we have an update. Okay.
All right.
Yes, ma'am.
Thank you, Your Honor.
All right.
Pardon me, Your Honor.
Yes.
Breakout room was successful. We can go ahead and pass on the hearing. We've reached an agreement.
Okay. And remind me which, is that the last case, Aguilar?
Exactly, Your Honor.
Okay. And are y'all going to present an agreed order, or are you doing a Rule 11? How's that going to work?
We'll do a Rule 11, and then I think the agreement is that we'll amend our petition to omit the gross negligence claims against DoorDash.
Exactly.
I'll make a docket note that reflects the agreement was reached, and y'all are excused from the virtual courtroom. Have a great one. Thank you.
Thank you, Your Honor.
Okay. Let's see. I think that is going to take us to Jackson versus Asadi and Uber et al.
Morning, Your Honor.
Good morning. All right. And so let me just ask, is there also a continuance motion set on this, or just was that filed as a response?
So, Your Honor, there is a request for, well, there's a motion for continuance in plaintiff's response. We also filed a motion for continuance of the trial setting in the DCO, which we were not able to set for this morning. So, you know, while we're ready to argue the whole MSJ, as you can tell, the continuance issues and related things, how they fit together is really at the forefront. So if we want to start there, we can.
Okay, well, I mean, if the continuance relates to the MSJ, I think it makes sense to talk about that first. But if it's related to the trial date and needs to be set on another date and time, then I wouldn't entertain that if it hasn't been set today.
Understood, Your Honor. And the reason I bring it up is because all these issues do kind of fit together. But if it happens to be at the end of the hearing that we need to take up the ultimate continuance separately, that's fine.
All right. So the plaintiff filed a continuance of defendant's summary judgment motion. So why don't we start with that first, and then we can, depending on how that goes, we'll get to the motion or we won't.
Your Honor, given that it's our MSJ, I'd like to go first if that's the case. I plan to start with the continuance issue.
All right. Well, I'm going to hear it one way or the other. So, Mr. Hargis, is that okay with you?
That's fine, Your Honor.
Okay. Go ahead, Mr. Larson.
Thank you, Your Honor. So our MSJ was originally set for hearing back in March of 2024. So March 27th was the original hearing date. At that point, and I just want to go through some of the procedural history so you understand kind of where things are at, and I'll try to be as brief as possible. But it was originally set then. The plaintiff had argued for a continuance of that setting of the MSJ because it hadn't deposed. Plaintiff had not deposed Uber's corporate rep. We decided to pass that hearing. And then plaintiff took Uber's corporate rep on April 24, in April of 2024. Plaintiff then waited until June and filed the motion to compel additional depositions of Matthew Baker and Alex Rosenblatt, which are pertinent to the motion before us. That motion was set for hearing on July 25th, 2024. Plaintiff decided to pass that hearing. I don't think we were advised of the reason why, but it was passed. It was then reset at the end of October. So about 3 months, a little over 3 months later. That hearing did go forward on October 28th, 2024. The court it was heard in another department, and that motion was to compel the depositions of Alex Rosenblatt and Matthew Baker was taken under consideration. At that point, Your Honor, we were running up against deadlines under the current DCO. The current DCO sets January 6th as both the date for dispositive motions to be heard, but also the date after which no evidence motions have to be heard or can be heard. So it kind of creates a conundrum of if you have a traditional and no evidence MSJ, you want to be compliant with both those deadlines at the same time. So at that point, we had not heard anything on the motion to compel those depositions in terms of a court ruling. So we set the hearing on November 13th for December 16th. At that point, we did not hear anything still on the court's ruling on those depositions, whether they were going to be compelled or not, until about 2 days before the December 16th MSJ hearing. At that point, it's Thursday late in the day, the hearing set for Monday. We decided to pass the hearing and reset it for the only possible date, which was today, to stay within that, walking the line on that December 6th date, the January 6th date. That's both the dispositive motion hearing deadline and the date after which no evidence motions need to be heard. So there really wasn't much time, to stay compliant with where we were at, to reset it. So that's why we're here today. As far as, an additional timeline there, I think plaintiff may raise the fact that we haven't provided dates for that deposition. We can get into that if we need to. We also filed a motion for reconsideration, which was timely. We filed it on as soon as we were aware that the court had issued a ruling compelling those depositions. There was actually competing forms of order that was submitted. Then the court signed an order, which is plaintiff's version, and mailed it, but did not do any kind of electronic. We weren't aware of it until we just happened to check the docket on the day after Christmas. So we essentially had until December 30th to provide those dates for that deposition of Baker. Instead, that day, we filed a motion for reconsideration and a motion to continue the trial setting, given the issues with the DCO and the fact that we're 3 weeks out right now from the discovery deadline. The witness in question that dates were to be provided for, since all of these issues are pending, is now on parental leave until April 2025. So as you can see, I'm just trying to lay out for the court that there's multiple issues here that are leading us to where we're at as it relates to continuance and to the MSJ. So in terms of, I think plaintiff may argue that to the extent it's even relevant here, that we didn't provide dates timely and violated the court's order. Mr. McLeod, who's within Mr. Hargis's firm, has made threats that he's going to seek relief along those lines. Again, I mean, what his argument is that we should have provided dates on that Sunday, despite the issues with the witness and the fact that under TRCP 4, the date by which we had to provide those deadlines would be the day after, which was the day we filed the motion for reconsideration. So, in our view, I think it's pretty clear that we were compliant with that. And even if we were to provide dates in addition to seeking reconsideration of the court's ruling, it wasn't even possible at that point because the witness, since that motion was argued and no ruling was issued, went on parental leave. So, I mean, it's my understanding, even just from Your Honor's comment, that we're not going to take up the overall trial continuance, but the issues are, like I said, tied. Right now we have a DCO that requires us to at least take up, I think, the traditional aspect, the traditional MSJ by today. And without an agreement from plaintiff's counsel on a continuance of the trial setting or DCO, where that's kind of why we're in a pickle here on why we needed to address the issues today, either as it relates to the broader DCO and trial setting, or we can argue the MSJ, which we're happy to do. So that's kind of where we're at in terms of procedural history, Your Honor. Happy to answer any questions on that, but that's where we're at.
All right. So I thought, Mr. Larson, you said this is my motion, so I want to go first. But you didn't argue your motion. You kind of argued your response to the continuance, maybe, I think.
Your Honor, I'm happy. Like I said, I'm happy to argue the overall MSJ. I'll do it right I just don't want to waste the court's time at the same time. I I understand what you're saying. I just wanted to lay out the procedural history for the court. It is on our motion, so that's kind of.
Let me ask you this. Have you contacted Judge Slifer to get a hearing on your motion for reconsideration?
Yes, Your Honor. We're trying to get the consideration motion and the motion for continuance heard at the same time if possible, but I think the dates that we had gotten at the end of last week was January 21st or 22nd.
Okay. All right. Let me hear from Mr. Hargis, I guess, and then we'll circle back around.
Thank you, Your Honor. So the first thing I would start with is in their reply, in Uber's reply, which was filed Friday evening, they acknowledged, and in fact, they agreed that a continuance of both the briefing deadlines and this hearing was necessary. Mr. Larson just said that Alex Rosenblatt and Matthew Baker were both pertinent to the motion before us. That was one of the first things he told the court today. Ms. Rosenblatt, we've learned, is no longer employed by Uber. That's fine. Mr. Baker, we've been requesting dates since February 28th, 2024, and dates have never been provided. When we first asked for dates, Mr. Larson didn't know who Mr. Baker was. But then after that, we learned that somehow he's an apex witness. And that's despite the fact that my colleague, Mr. McLeod, has deposed him before in an arbitration setting. He's deposed Alex Rosenblatt before. So we fought this out. Dates were never provided. We filed our motion. Judge Slifer heard arguments on October 28th. And at the end of the day, our argument prevailed. And we learned on December 12th that an order needed to be submitted. We asked Uber multiple times if they agreed to our order, which asked that dates be provided within 10 days, typical order, and heard nothing. So then we had to submit our own order, which was signed on the 19th. Then we never got dates for Mr. Baker, and now we're learning that he's out on parental leave. I believe this continuance is necessary. We don't have to get into the trial continuance right now, but we've gone through this 3 times now. We've responded and we've included an alternative motion for continuance because we don't get dates for Mr. Baker. And we believe that Mr. Baker's testimony will go directly to our direct negligence claims against Uber. And until Mr. Baker can be deposed, we don't believe that we can adequately respond to the summary judgment. And that's why we're asking the court to go ahead and continue both of these summary judgments until the time that we can take Mr. Baker's deposition, whenever that may be, and then respond fully once we get the transcript back. And one more thing, Your Honor, as Mr. Larson mentioned, the continuance is set for the 21st about the trial continuance. Obviously, if he's not available till April, I mean, it's not going to be a long deposition. The corporate rep went 2.5 hours. We're not going to take 6 hours with Mr. Baker. But if he's not available until April, obviously that's going to affect the trial setting. And I think we deal with that on the 21st. But for the purposes of today, we're asking the court to sign an order continuing these hearings until we can depose Mr. Baker. And one more thing, Judge, we've asked depose dates for 2 more witnesses, and Uber hasn't provided dates for those witnesses either that we believe support our claims. So I expect we're gonna have to file a motion to compel on that as well, on top of responding to the motion for reconsideration, which Uber's counsel has already indicated they'll be filing a mandamus if it's denied.
All right. Mr. Larson, anything else as it relates to the continuance?
No, Your Honor. I mean, you know, I understand the motion for continuance of the trial setting is not set for today. I guess, hopeful that we could, since we're all here, the motion's been on file, we're all understanding the issue, that we could take it up. I understand it's not noticed for today's. So if that's where we're at, and in terms of we can't make any progress other than just deciding whether this hearing is continued, then that's understood, Your Honor, and it makes sense. You know, I just was, I guess, hopeful that since we're all here, that we could make some progress on that front instead of having to come back on that specific motion.
Okay, well, it sounds like in light of the fact that certain things in the case haven't happened, depositions, y'all all know you're not going to be ready for trial on your setting. you are certainly welcome to confer and contact court admin. The sooner you get an alternative date, the better line number you will have. The later you wait to do that, the worse off you will be. However, you know, what judges are pretty loyal to our local rules. We think we only have hearings on things that have been filed, set, and noticed for today. So no, I'm not at all interested in taking up anything that is not set for today. I leave you to confer and hash that out, but I do think the continuance of the MSJ hearing has merit, and I will grant it. Mr. Hargis, do you have an order to that effect, and has it been emailed to my staff?
Yes, ma'am. I sent Ms. Seeger a order in Word format this morning.
Okay. Any issue with the form of that, Mr. Larson?
Your Honor, I did see it come through this morning. If
You want to take a quick look at it?
Yeah, if I could, Your Honor.
Sure.
I think the only issue I have with it is this phrase "are premature," referring to the motions. I think it should just say defendant's motions for summary judgment. It finds that plaintiff's verified motion for continuance should be granted. So, I mean, unless Brett has an issue with that, I would just propose that the phrase defendant's motions for summary judgment are premature, and then strike through that. And then other than that, no issue.
I'm completely fine with that, Judge.
Okay.
Would you like me to make that change and resend, or?
Yeah, if you have time, that would be
Absolutely
helpful.
Certainly.
Okay. We'll look for that updated order and get that entered. Seeing nothing else, you are excused from the virtual courtroom. Thank you, counsel.
Thank you,
Your Honor.
Judge.
Thank you,
That's
Judge.
for the new year. Who is next?
Happy New
We
Year.
have special exceptions on Riley versus Cornerstone. And let's see.
I believe that's Tommy Gillespie's motion, as well as the other attorney, Mitchell Ginsburg.
Okay, and y'all didn't need a record, right?
No, we don't.
Okay.
Your Honor,
go ahead.
Good morning, Your Honor. Mr. Rudder indicated that we might be able to agree to things. I had reached out over the holidays, and Mr. Rudder and I just kind of missed each other going back and forth. So if we can put some stuff on the record as to agreements, I think that cut to the chase.
Okay, well, you said you didn't need a record, so I let my court reporter go. But
I'm sorry, I didn't mean. I trust Mr. Rudder if he.
We can do a Rule 11 agreement.
Okay. Why don't y'all tell me what the agreements that you have reached are, and if y'all plan to do a Rule 11, that will satisfy the court.
Plaintiff will amend his petition to allege a premises liability claim only and remove any and all negligence claims or negligent activity claims therein the current petition. So we will streamline that part of it. As far as the amount to be pled pursuant to Rule 47, we've got that in our latest amended petition. I just think Tommy has some issues with it. So I'll let him address that with the court.
Okay, Mr. Gillespie.
Well, Your Honor, it might be I just missed it, but I'm kind of scrolling through.
It's at 9.03 of the third amended petition where we've alleged $1 million pursuant to Rule 47.
Well, Your Honor, I believe the rule, if we look at the rule, it's a maximum amount, not seeking monetary relief over 1 million. He needs to state what the maximum amount is. So saying an amount over something is not my understanding of what Rule 47 requires when it's brought to plaintiff's attention.
I'll let the court direct me on how to state that.
Okay, well, let me look at the plain language. Okay. And how does it read right now? Over 1 million?
Plaintiff affirmatively states that they seek monetary relief of over $1 million.
And isn't that, I mean, that's a specific provision of 47, right?
Yes, sir. Yes,
It
Your
is only one part of 47. There's the part that says when you specially accept, they have to state a maximum amount. I can pull it up.
Okay, let me read through the whole thing. Okay. All right, that is in subsection D, that if they specially accept, I shall require the pleader to amend as to specify the maximum amount of damages. So, Mr. Rutter, I guess I will advise you to do so.
We will do so. We will do so.
Okay, great. All right. And
the final aspect, Your Honor, was no gross negligence in this case. If Mr. Rutter thinks there is, he needs to specifically plead the subjective and objective, because right now it's just there's and gross.
And Judge, frankly, we've got probably some depositions that need to be taken of some other parties that might go into that aspect. I don't know if it will, but if we can get those people deposed, then maybe we can agree to either remove that or go forward with it. So right now we've alleged it because we believe it to be true, but we haven't taken that deposition yet. But we've got mediation scheduled in a couple of days. Frankly, we might be able to get the case resolved. If we can't, then we'll notice those depositions and move forward with that. So if the court can give me some time on that issue, I would appreciate that.
Your Honor, I don't mind giving Mr. Rutter or any plaintiff some time, but I would like some guidance, it's basically there's gross negligence. If he thinks that there are facts that would support that and he's just trying to discover them, I think in order for me to prepare defenses and to be ready in these depots, there should be some fair summary. Fair notice, I believe, is the way the courts talk about it, so that I'm not just kind of sandbagged.
all right. Mr. Rutter, any other thoughts?
No, Your Honor, not at this moment.
Okay. And who's the deposition that you think is going to shed light on this issue?
The defendant has third-partied in a couple of entities. We took Mr. Turbay's deposition. He is of Bennett Paving, and he absolutely knew nothing about what the person that we need to depose, which is the striping contractor. He didn't know anything about what that striping contractor did. I assume that that's the person, and I don't know the name of this person off the top of my head, but that is the person that we need to depose to determine what exactly he did or did not do that could enlighten us as to gross negligence claims. This is, Judge, just to give you a little background, this involves a ramp going into a Denny's that was, not consistent with the building codes, and it was or was not painted. We don't know if it was painted, but if it was painted, did they put the grip, the shark grip in the paint, or did they just coat it with paint and make it slippery? We don't know that. So the element of gross negligence will come down to what, in fact, this person did, this entity that was third-partied in. So that is the person that we need to depose. And I think if Tommy thinks about it, he agrees with that we need to pose him and figure out what he did or did not do so as to determine that element of gross negligence.
Your Honor, if I may briefly respond, Judge Hurley ordered the leave for us to bring in these two defendants, one being H&R Striping, back on, and July of 2022. It is now January of 2025. So over this time period, knowing that H&R Striping was designated as a responsible third party in August of 2022, no one's ever tried to take Hector Ramirez's, the H&R, his depot. So with that said, I just believe that as to Cornerstone, who hired Bennett, who hired H&R, I'm trying to, what in the world could we have done or failed to do that is grossly negligent with not a sub, but a sub of a sub who plaintiff has never sued and now can't sue? So I need some help on what did we allegedly do or fail to do. And I appreciate Mr. Ramirez has not been deposed, but I just cannot, I'm having a hard time trying to defend my client on gross negligence without some sort of fair notice as to what I did, not what Mr. Ramirez may or may not have added to his paint.
Well, Judge, if I may, Tommy just noticed Mr. Turbay's deposition. He is one of the third parties that they brought in. He noticed that deposition. I don't think he found out anything from Mr. Turbay that Mr. Turbay knew or didn't know. I mean, he did not know anything about anything as it comes to striping because he didn't do it. So I would assume that that was part of Tommy's efforts to determine what happened. I'm surprised that he hasn't noticed Hector Ramirez's deposition. I'll go ahead and notice it right now. I don't know that he has any control. I don't even know if Hector is represented in this case. And if he's not, then, you know, that's going to take some time to get him served and get him deposed. So, you know, frankly, I didn't think that the third party petitions were filed timely. They were filed well after the statute of limitations expired. And I'm sure Tommy's going to tell the court that we had an improper date in our petition at some point, but this incident happened in January. And then 2.5 years after the statute, or I guess a half a year after the statute expired, they brought in these third parties. We didn't object to it because we felt like it was untimely, and that may be my fault, but we believe that the third parties weren't designated, at least by one party. There was not a full designation of Hector Ramirez as being a person that could be brought into this suit prior to the statute. Now, Bennett Paving, they were identified by one party, but not the other party. So there's a whole slew of issues that we can talk about that aren't set for today, but we'll get Hector Ramirez's deposition scheduled and get that done ASAP.
All right, Mr. Rutter, do you think you can get that deposition noticed by the end of the month?
I think I can get it noticed. I don't know if I can get it scheduled because with 3 attorneys, finding a common date could be rather difficult.
Okay. What I will do is I'm going to ask that you take the deposition within the next 60 days. And then 14 days after that deposition, you will either drop gross or provide some facts so that Mr. Gillespie understands the basis.
That's fair enough.
Okay.
Fair enough.
All right. Well, I think that covers it for y'all.
It does. That does, Your Honor.
All right. I'll make a docket note if you want an order, put one together and send it to Miss Seeger. We'll get it signed.
Okay.
All right.
Thank you, Judge.
Y'all have a good New Year. Give her
Appreciate you. Happy New Year.
Your Honor, I am trying to find, I'm sorry. They are emailing it to you now. They informed me that they didn't get assignment to your court until after 5 on Friday, and so they weren't able to send over. Their staff goes home, unfortunately, at 5, and so they weren't able to send that to you before, and they should have, I guess, realized this morning that they hadn't sent it and gotten to you before docket call at 9. I do apologize. They are emailing it now. I'm hoping that they're sending it to the correct email address. I've asked for them to CC me on that. I'm not sure how the court would like to proceed. If you'd like to reset for later this week, give you a couple of days, or if you feel okay doing that, we're more than happy to do whatever feels, give you an ample amount of time to review.
Okay, well, let me just check with my staff to see.
Okay.
I don't think anything has arrived yet.
Okay. Okay, she said that she did send it and she CC'd me. Let me see.
Your Honor, I'm just going to step away for one quick moment.
Okay, that's fine.
I do see the one for Mr. Tweeton has been sent. Let me check on the other one. And she did send it to Pam Seeger. That is correct. Let me see if the other one, why there's a delay on the other one. I'm so sorry, Your Honor. Give me a moment.
Okay, thank you.
Come here, baby. Hi. Oh. Calm down, sweetheart. Good girl. I'm sorry about the sporadic appearance of my dog.
That's okay.
It's too cold outside. Come on.
Your Honor, I have just received the email with the attachment for Ms. Patton Shuli's application that's unredacted.
Okay. All right.
And then we also sent the other one for Mr. Tweeton as well in a separate email.
I think they were in the same email, actually.
Oh, they were? Okay. Yeah, my duplicate one only had one attachment, so I asked them to resend it because it could have been my Gmail. Looked weird.
All right, Ms. Wilson Salazar, what I'm going to ask you to do is, since I haven't had these materials, or they just arrived, I guess.
Sure.
I am going to ask that, so I'm going to do something that I do frequently in these cases. I'm going to appoint an attorney ad litem.
Okay.
Annuitant. If you, and we will appoint an attorney ad litem off of the wheel, but if you will send a proposed order simply doing that for both Ms. Patton Schul and Mr. Tweeton, we'll get the attorney ad litem appointed so they can review these proposed sales on behalf of the annuitants, advise them, and then if they still desire to go forward with the sales, transfers, etc., then you will reset the hearings.
Okay. We
All
can
right.
do that. I will
Let
do
me ask Mr. Tweeton to turn on his video. I just want to explain what the court is doing to hear so you understand. And
yes, ma'am, I'm here listening.
okay, so you understand Miss Wilson Salazar, she represents J.G. Wentworth.
Yes, ma'am.
Okay.
Yes, Your Honor, sorry.
That's okay. And you, neither you nor Miss Patton Schul have a lawyer representing you.
Correct.
Okay. So what the court is going to do, these structures, you know, they can be pretty weighty financial transactions. There's consequences.
Yes, ma'am.
An attorney ad litem is someone that I am appointing who represents each of you. And this person is going to review the sale from your perspective, not from the perspective of J.G. Wentworth. And they're going to advise you whether it's a good deal, a bad deal, whether you should take it or leave it, answer all your questions and satisfy you so that if you do still want to go forward, that basically covers all those issues. And so if
may
you
I
want,
interject?
you can ask a question.
Oh, I don't really have a question. I was just gonna say I do understand that from my perspective, this is more than a bad deal for me, but I don't really have a choice. I'm kind of broke at the moment, and my husband did actually just get a job, but he's being paid bi-weekly, and his first check that he got was only for his first 2 days of work that he did, and so it didn't cover all of the expenses that we need. And so it is pretty much absolutely imperative that I get this sale done as quickly as possible for myself, so that I can start taking care of our needs while his checks start to get more substantial in the coming weeks, so that, you know, we can start saving up now that he actually has a job.
Okay. Well, under the law, there are certain requirements that have to be done.
I do understand, and I still don't mind waiting until, you know, next week. I just don't need the attorney ad litem to, you know, direct me, because I do understand that it's a bad deal on my part, but I have to do it. I don't have a choice, or else, you know, my bills are going to overwhelm me before my husband gets paid the next time he gets paid.
Okay. Well, it's not your choice. It's
Yes.
a decision I've made. I will not approve the settlement without.
Oh, I know. I'm not saying you have to approve it today. I don't mind waiting for when you're ready. I'm just saying I don't need the attorney ad litem to direct me, is all I'm saying.
Okay. Well, that's not up to you, because I'm appointing an attorney ad litem for each of you.
Okay.
All right. Okay, Ms. Wilson Salazar, if you can get those orders to my staff, then we'll leave a blank. We'll fill in the attorney. We'll get them assigned out, hopefully today, so that they can get to work on these matters, review the documents, talk to the annuitants, and help them going forward if they do, in fact, want to pursue these transfers.
Will do, Your Honor.
I have a question.
Sure, Hans, go ahead.
What is like, I'm sorry, before y'all had the conversation about why she had needed the money. You were saying like the process of like everything that happens, like whenever he gets whenever the other attorneys like get the information on our behalf, like what goes on after that?
They'll review it and they'll speak with you directly about the deal.
Yeah, so fine.
They'll help you evaluate whether it really is something you want to go forward with or not, whether better terms could be negotiated, whether you should do something else. I mean, they're an advisor to you.
Yeah, for sure.
Your counselor.
Love that.
Okay. All right.
All right.
And then if you're still ready to go forward after you've talked to them, then Ms. Wilson Salazar will help you get the hearing reset.
All righty.
Okay. All right. Well, best of luck to you. Happy New Year. Y'all are excused from our
Thank
group.
you. Thank you,
Thank you very much.
Thank
My
you.
apologies for making that longer than necessary.
No problem.
All right. Thank you, Your Honor.
Thank you.
Thank you.